consolidated with Nairobi petition number E550/2024, Nairobi petition number 570 of 2024, number E572 of 2024, Kerugoya petition number E013 of 2024, Kerugoya petition number E014 of 2024, Kerugoya petition number E015 of 2024, Nairobi petition number E522 of 2024, Nairobi petition E506 of 2024, Nairobi petition E509 of 2024, Nairobi petition number E525 of 2024, Nairobi petition number E528 of 2024, Nairobi petition number E537 of 2024, Nairobi petition number E541 of 2024, E567 of 2024, E576 of 2024, E586 of 2024, and E598 of 2024 between Honorable His Excellency Rigathi Gachagua.
No, it's not. It's the second last petition. It's not part of
Yeah. Petitioners Rigathi Gachagua, Thomas Kimotho Maingi, John Jerry Maina, David Munyi Madenge, Peter Gichobi Kamotho, Grace Mudomi Mwangi, Clement Mchiri Murioki, Edwin Munene Karioki, Sharia Mtani, na Shadrack Wambui, Father Eddie Waiguru, Anthony Mwithaga, Victor Gatia, Asunta Wangui Mwiruri, Christine Mukami Njuguna, Peter Kimani Kioira, Alice Wamuhu Mbugwa, Mwangi Anyeki Mbugwa Wamumbi, Kigo Kahari, Priscilla Wambui Gitari, Muchiri Ngatia, Maria Njeri, Eric Warui Mwaniki, Brian Hunja, Sarah Hubi, Margaret Wanjira, Samuel Njenga, Hebron Gakuru, Samuel Ngari, I accept, Council, that the parties are known. We can move ahead, and others versus the respondents. Speaker of National Assembly of Kenya, Speaker Senate of Kenya, Honorable Attorney General, and several others. This is the judgment.
For the sake of clarity, I believe the lead file in terms of the directions that this Honorable Court gave is E565.
Yes.
That is not quite what I heard.
Yeah, that is the lead file.
That is the position.
Yes.
Thank you.
This is the judgment. We have a 350-page judgment, and we'll try as much as possible to read it. Introduction and background. In the general election of 9th of August 2022, the first petitioner, hereinafter referred to as His Excellency Gachagua, was elected as the Deputy President of the Republic of Kenya alongside His Excellency William Ruto, whom we refer to as President. Their election was upheld by the Supreme Court, paving the way for their swearing in on 13th of September 2022, beginning what was expected to be a full constitutional term under Article 145, Sub-Article 1, and Article 148, Sub-Article 6. That expectation, however, was cut short following the successful impeachment proceedings against His Excellency Gachagua. The process leading to his removal commenced on 1st of October 2024, when Honorable Mwengi Mutuse, the 9th respondent and Member of Parliament for Kibwezi West constituency, we shall refer to him as Hon Mutuse, introduced an impeachment motion pursuant to Article 145 and Article 150 of the Constitution. The motion hereafter The motion, referred to as impeachment motion, cited multiple grounds, including allegations of gross violation of the Constitution, incitement, and undermining government policy. The 11 grounds were as follows. Ground 1, gross violation of Article 10, Sub-Article 2A, B, and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A, and 2B, Article 75, Sub-Article 1C, and Article 129, Sub-Article 2 of the Constitution, and Article 147, Sub-Article 1, as read with Article 131, Sub-Article 2, C, and D of the Constitution. Ground 2, gross violation of Article 147, Sub-Article 1, and 152, Sub-Article 1 of the Constitution by undermining and the Cabinet and effective discharge of the national government's executive mandate. Ground 3, gross violation of Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, Article 189, Sub-Article 1, and the fourth schedule to the Constitution by undermining devolution. 4, gross violation of Article 160, Sub-Article 1 of the Constitution on the institutional and decisional independence of judges. Article 5, Ground 5, gross violation of Article 3, Sub-Article 1 and Article 148, Sub-Article 5A of the Constitution, and fidelity to the oath of office and allegiance. Ground 6, serious reasons to believe that Rigathi Gachagua had committed crimes under Sections 13, Subsection 1A and Section 62 of the National Cohesion and Integration Act. Ground 7, serious reasons to believe that Rigathi Gachagua has committed crimes under Section 45, 46, 47, and 48 of the Anti-Corruption and Economic Crimes Act and Section 2, 3, 4, and 7 of the Proceeds of Crime and Money and Anti-Money Laundering Act. Ground 8, serious reasons to believe that Rigathi Gachagua has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Ground 9, gross misconduct under Article 150, Sub-Article 1B of the Constitution by publicly attacking and undermining the work of the National Security Intelligence Service and its officers. Ground 10, gross misconduct or insubordination by openly or publicly insubordinating the President, who is the head of state and government. Ground 11, gross misconduct by persistently bullying state and public officers. The impeachment motion was formally initiated before the second respondent, that is the National Assembly. In response, several constitutional petitions were filed in the High Court, challenging both the legality and constitutionality of the National Assembly's proceedings. These petitions, consolidated with Nairobi petitions, which I had mentioned earlier, were consolidated and are collectively referred to as the Cohort 1 petitions, with petition number E522 of 2024 designated as the lead file. 56, that was Cohort 1 petitions. Cohort 2 petitions, where these petitions belong, the lead file is 565 of 2024. On 8th of October 2024, the National Assembly passed the impeachment motion. Subsequently, the resolution was transmitted to the Senate. As the impeachment process unfolded, further applications were seeking conservatory release were filed in the High Court to restrain the Senate from proceeding with impeachment hearings. The Senate thereafter conducted its hearings and upheld 5 of the 11 charges against His Excellency Gachagua, as a result of which he effectively ceased to hold office as Deputy President of the Republic of Kenya. The Senate's decision was communicated to the public through a Gazette notice issued on 17th of October 2024. Following the impeachment, His Excellency President Ruto nominated Professor Kithure Kindiki, the second interested party, whom we shall refer to His Excellency Kindiki, to fill the vacancy in the office of the Deputy President. The National Assembly voted in favor of the nomination, and His Excellency Kindiki was sworn into the office on 1st of November 2024. As the Senate proceedings that culminated in the impeachment of His Excellency Gachagua were underway, and while the National Assembly was concurrently addressing the vacancy created in the office of the Deputy President, further petitions were filed in the High Court at Nairobi and Keregoya, including petition number 565 and several other petitions, being designated with petition number 565 of 2024 being designated as the lead file. Conservatory orders were initially issued restraining the swearing in of His Excellency Kindiki as Deputy President, but those orders were later lifted by this court in its ruling of 31st of October 2024, paving way for the swearing in as earlier stated. Thereafter, the pleadings were amended and cohort 2 petitions proceeded for hearing, culminating in the present judgment. We will now proceed to summarize the parties' pleadings and submissions in the cohort 2 petitions. Summary of pleadings and submissions. His Excellency Gachagua is the first petitioner. His case is as follows. He anchored his case on the further amended petition dated 13th of August 2025, supported by his affidavits deposed to on 18th of October 2024 and 27th of October 2024. Speaking to the deficiencies in the process before the National Assembly, His Excellency Gachagua deposed that the impeachment motion lacked the particularization and specificity required under Article 145, Sub-Article 1 and Standing Order Number 64, 1A. He took issue with the lack of credibility in respect of the charges against him in the National Assembly and the Senate. As regards the constitutional imperative of public participation, His Excellency contended that the National Assembly's process was deficient in that the notice was unreasonably short and that it lacked adequate designated venues. It was his case that the exercise was biased, with organizers framing it as meant for invited members of specific parties. He stated that the process utilized unverified feedback forms that resulted in fictitious data. In alleging bias exhibited by the Speaker and Deputy Speaker of the National Assembly, His Excellency deposed that they made partisan statements and also failed to recuse themselves despite having conflict of interest as they were signatories to the coalition agreement that formed a substantial part of the evidence. It was his case that the Senate violated Articles 145, Sub-Article 3 to Sub-Article 6 by skipping the appointment of a special committee to investigate the charges against him, thereby denying him a crucial layer of fair hearing. He stated that Senate imposed an unconstitutional 10-day deadline on the plenary proceedings and unlawfully permitted the National Assembly to introduce new evidence by ambush. He was emphatic that the Senate violated his right to a fair hearing and dignity guaranteed under Article 50 and Article 28, respectively, when he was denied an adjournment. In further support of this position, Dr. Daniel Kibuka Gikonyo, a consultant cardiologist and founder of the current hospital, saw an affidavit on 28th of April 2026 to confirm the medical status of His Excellency Gachagua on the day he was scheduled to defend himself before the Senate. Speaking to the key medical events, it was his evidence that on 17th of October 2024, at approximately 3 p.m., His Excellency Gachagua arrived at current hospital with severe chest pain. He deposed that given his age and underlying risk factors including hypertension, history of diabetes, stress, he conducted ECGs and blood tests and recommended a 48 to 72-hour admission to enable close monitoring, further evaluation, and appropriate medical management. It was his evidence that he supervised His Excellency Gachagua's care until discharge on 20th of October 2024. Far from the impeachment process, His Excellency Gachagua impugned the subsequent nomination and approval of His Excellency Kindiki. He asserted that the process was rushed and there was no public participation despite the dictates of Articles 10 and 118 of the Constitution. It was his case that the clearance from the Independent Electoral Boundaries Commission, or IEBC, was null and void since the commission lacked commissioners, and as such, the Secretariat was legally incompetent to clear the nominee. Further to the foregoing, it was His Excellency Gachagua's position that His Excellency Kindiki was disqualified under Chapter 6 due to gross human rights violation, including abductions, extrajudicial killings during the Finance Bill protest when he served as Interior Cabinet Secretary. Finally, His Excellency Gachagua averred that His Excellency Kindiki was not a member of the UDA party for the requisite 3 months preceding his nomination, and it was his case that the National Assembly unconstitutionally metamorphosed the process into an election rather than an approval under Article 149, Sub-Article 1. For these reasons, His Excellency Gachagua sought the following reliefs: a declaration that the respondents have contravened the provisions of Articles 10 and 18, Sub-Article 1, Articles 10 and Article 118, Sub-Article 1 of the Constitution, by initiating a process leading to the removal from office by impeachment against the petitioner without first putting in place adequate legislative and procedural measures for effective public participation. In particular, the Senate's decision was not informed by any input from public engagement. 2, a declaration do issue that the impeachment motion lacks the particularization and specificity required under Articles 145, Sub-Article 1 of the Constitution and Standing Order 64(1)A of the Standing Orders of the National Assembly, and is thus incapable of invoking the jurisdiction of both the National Assembly and the Senate under Articles 145 and Article 150. 3, a declaration that the resolution passed on 18th of October 2024 by the National Assembly purporting to impeach the petitioner pursuant to the provisions of Articles 145 and 150 and the communication dated 8th of October 2024 by the Clerk of the National Assembly to the Clerk of the Senate titled, in quote, Resolution of the National Assembly on a special motion on the removal from office by impeachment of His Excellency Gachagua, Deputy President of the Republic of Kenya, close quote, are both founded on a process that is inconsistent and in violation of the Constitution of Kenya and are thus both void and invalid. 4, a declaration that for the purposes of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. 5th, he sought a declaration that the period of 12 days provided under Standing Orders number 64, sub-order 2 and 6 of the Standing Orders of the National Assembly is grossly insufficient time for the National Assembly to facilitate any meaningful and reasonable public participation during the process of impeachment of the President or Deputy President of the Republic of Kenya. Thus, the Standing Order is unconstitutional insofar as it has the effect of abridging the time for public participation. 6, he sought a declaration that the proceedings before whole house plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited or time-bound to 10 days, as would be if a special committee is appointed under Article 145, Sub-Article 4A. He also sought in 7th prayer a declaration that the petitioner's right to fair administrative action under Article 47, right to fair hearing under Article 50, Sub-Article 1 of the Constitution were violated on account of the petitioner being denied an adjournment occasioned by illness, thus violating his right to appear in person before the Senate of Kenya to be heard and present his case. He also sought a a declaration that the National Assembly and the Senate, in their evaluation of the impeachment proceedings before them, failed to properly assess each of the specified grounds and determine if they collectively or individually constitute a gross violation of the Constitution, warranting voting to uphold the impeachment charges against the petitioner. Hence, the resolution of 8th of October 2024 in the National Assembly and the vote upholding the impeachment charges that of the Senate passed on 17th of October 2024 do not meet the threshold for impeachment set out under Article 150 as read with Article 145 of the Constitution. Hence, the same be and are hereby set aside. An order of certiorari to remove into this Honorable Court and quash the decision and or resolution of the National Assembly and the Senate made on 8th of October 2024 and 17th of October 2024, respectively, resolving to remove from office by impeachment His Excellency Gachagua, EGH, Deputy President, Republic of Kenya. At the 9th prayer, the petitioner sought an order of certiorari to bring up into this court to be quashed the resolution of the Senate of Kenya made on 17th of October 2024 to remove from office by impeachment His Excellency Gachagua, EGH, Deputy President, Republic of Kenya, on the grounds expressed in Gazette Notice number 13/400. He also sought at prayer number 11 a declaration does issue that the IEBC could not clear Kithure Kindiki without the involvement or approval of commissioners under Article 88 and Article 250, Sub-Article 1 of the Constitution as read with Section 4 and Section 11A of the IEBC Act. The purported clearance was therefore null and void. Further, the overnight clearance violated Article 10 of the Constitution on openness and transparency. At prayer number 12, His Excellency sought a declaration does issue that Kithure Kindiki is disqualified under Article 10 and 72 of the Constitution due to unresolved concerns from his tenure as Cabinet Secretary for the Interior and National Administration, during which Kenya endured gross violation of human rights. He also sought a declaration does issue that the National Assembly violated Articles 124 Sub-Article 4 and Article 149 Sub-Article 1, Section 6 of the Public Appointments Parliamentary Approval Act, Cap 7F, and Standing Order 45 in the method it adopted to approve Kithure Kindiki's nomination as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and procedurally cleared and unlawfully approved as nominee for Deputy President in violation of Articles 1, Article 10, Article 8, Article 118, Article 124, Article 137, Article 148, Article 149, and Article 250 of the Constitution, so that his appointment, clearance, and approval for that position is null and void. At prayer 15, he sought a declaration that the petitioner suffered harm and is therefore entitled to constitutional damages as compensation for the violations against him in terms of general damages, punitive and aggravated damages, security to be specified at the hearing, special damages under Gazette Notice number 10346 of 2023 for loss of 1, salary, 2, official transport, and other prevailing transport policy for 35 months, medical cover and benefits detailed to be supplied, airtime, gratuity, and annual salary for 5 years. He calculated those sums and gave the figures. At prayer number 16, His Excellency sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act, Chapter 197B of the Laws of Kenya, being a monthly pension equal to 80% of the first petitioner's last monthly salary while in office. 2, a lump sum payment on retirement calculated as a sum equal to 1 year's salary paid for each term served in office. 3, 2 saloon vehicles of an engine capacity not exceeding 2,000 cc, which shall be replaceable once every 4 years. 4, one four-wheel drive vehicle of an engine capacity not exceeding 3,000 cc, which shall be replaceable once every 4 years. 5, a fuel allowance equal to 15% of the current monthly salary of the office holder. 6, full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7, 2 drivers. 8, 1 personal assistant. 9, 1 accountant. 10, 1 secretary. 11, 2 housekeepers. 12, 2 senior support staff. 13, 2 cooks. 14, 2 gardeners. 15, 2 cleaners. 16, armed security guards, who shall be provided on the request of the first petitioner. 17, diplomatic passport for the first petitioner and his spouse. And 18, office and office equipment. 19, maintenance expense for the vehicles provided. 20, access to the VIP lounge 2 at all airports within Kenya. He also prayed for cost of this petition and such other reliefs as this court may deem just. In support of his claim, His Excellency Gachagua submitted, or rather in his submissions, he advanced his case further through written submissions dated 7th of October 2025, which were orally highlighted in court by his counsel, Paul Mute Senior Counsel, Elisha Ongoya Senior Counsel, and Mr. Ochiel Dudley, among others. The unifying premise of their submissions was that the impeachment proceedings were not purely political processes insulated from judicial scrutiny. Instead, they constituted constitutionally regulated proceedings subject to the supremacy of the Constitution, the doctrine of legality, and the supervisory jurisdiction of this court under Articles 23, 47, 50, and 165. Overall, they came up with the following issues for course determination. 1, whether National Assembly motion met the constitutional threshold under Article 145. 2, whether the Senate violated Articles 145 sub-Article 3 to 6 by failing to appoint a special committee to investigate the charges. 3, whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the petitioner a fair hearing. D, whether there was adequate public participation at both the National Assembly and the Senate. E, whether the speakers of the National Assembly and Senate were biased in reality or in perception. F, whether the overnight clearance and approval of a replacement of Deputy President evidence a predetermined process. G, whether Standing Order number 62 sub order 2 of the National Assembly is valid. And then, lastly, what are the available reliefs? They collectively, the lawyers for His Excellency, the petitioner, Rigathi Gachagua, collectively submitted that while Parliament undeniably possesses the authority to undertake impeachment, such authority is neither absolute nor immune from judicial review when allegations of constitutional violations, irrationality, or procedural impropriety arise. They characterize the proceedings as a politically engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while deliberately undermining constitutional substance, thereby necessitating judicial intervention to preserve the rule of law. Leading the charge on the constitutional standards of the process, learned Senior Counsel Elisha Ongoya anchored his arguments on constitutionalism and legitimacy within Kenya's presidential order. He submitted that the Constitution transformed governance from unrestrained political discretion to a system founded on constitutional limitation and accountability, which rendered all exercise of public power, including parliamentary impeachment, subordinate to the Constitution and amenable to judicial scrutiny. Describing the proceedings as an exercise in malicious compliance, he drew parallels to the historical trials of Socrates, Sir Thomas More, and Jesus Christ to demonstrate how processes can appear outwardly lawful while being fundamentally unjust and predetermined. He maintained that constitutional democracy depends on good faith, adherence to fairness, and constitutional morality, not merely technical compliance. In analyzing the text of Article 145 and Article 150, Council noted that the threshold language, gross violation, gross misconduct, and serious reasons prove impeachment is a mechanism reserved strictly for the gravest constitutional transgressions. To that end, Council drew the support from the cases of Mike Sonko, which we have particulars we have given, Muya and versus Tribunal appointed to investigate the conduct of Justice Martin Muya. We have given citation. He used these cases to argue that grounds must be substantiated by cogent evidence to an intermediate standard higher than a balance of probabilities. Senior Counsel Ngoya further submitted that since impeachment directly interferes with the sovereign will of the electorate expressed through universal suffrage, courts could not abdicate their responsibility by treating it as a purely political immune process. It was his case that the grave consequences of removal brought the matter squarely within the High Court's supervisory jurisdiction, requiring it to interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted on the democratic mandate and the political question doctrine. He was emphatic that impeachment in Kenya's presidential system is an extraordinary constitutional remedy of last resort. He distinguished Kenya's architecture from parliamentary systems where executive tenure relies on legislative confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate through universal suffrage and cannot be removed due to transient political dissatisfaction or partisan convenience. In view of the fact that impeachment effectively overturns the democratic will, it was Senior Counsel's position that the Constitution deliberately imposed strict procedures and substantive safeguards that courts are duty-bound to enforce. Learned Counsel drew support from the decision in Mike Sonko Mbuvi, which we have stated, to restate that the threshold for removal could not be reduced to political expediency. He further called to his aid the Court of Appeal decision in Martin Nyaga Wambora, we have given citation, to argue that judicial review of the proceedings affirmed constitutional supremacy rather than offend the concept of separation of powers. He firmly rejected the respondents' invocation of the political question doctrine, asserting that the Constitution creates no autonomous islands immune from accountability, and he maintained that all constitutional power remains subordinate to the judiciary's review. Learned Counsel Mr. Chiang Dudley submitted on jurisdiction and the mandatory duty to adjudicate. At the outset, he pointed out an alleged internal contradiction in the respondent's case, simultaneously conceding the court's jurisdiction while urging it to abstain from exercising it. He submitted that constitutional adjudication could not be avoided simply because a dispute implicated political institutions or carried political consequences. He took the position that once allegations of procedural impropriety or rights infringements arose, the process ceased to be purely political. Drawing on the United States Supreme Court decision in Cohens versus Virginia, we've given citation, he argued that a court acts just as improperly when it declines constitutionally vested jurisdiction as when it arrogates jurisdiction it does not possess. It was his case that Article 165 imposes a mandatory obligation on the High Court to determine disputes whose constitutional violations are alleged as such. The judiciary would itself violate the Constitution by declining to hear politically sensitive questions. Mr. Uchieng submitted further that separation of powers does not establish institutional immunity and that judicial review ensures Parliament acts within its boundaries. Citing the Supreme Court advisory opinion in the matter of Kenya National Commission on Human Rights, Council concluded that constitutional interpretation in such disputes must be transformative, holistic, and purposive rather than mechanical. In the written submissions, His Excellency Gachagua specifically impugned ground 8 of the charges, noting that it relied on Section 132 of the Penal Code, a provision already declared unconstitutional in Robert Alai versus the Attorney General matter. On the right to a fair hearing, he maintained that the Senate violated his inalienable right by proceeding in his absence due to illness, contrary to Article 50, Sub-Article 2F and Article 25C. He drew support from Karaoke versus Attorney General, where it was argued that denying an adjournment impacting a citizen's constitutional rights warrants careful circumspection. He further submitted that the rushed manner of the proceedings mirrored the predetermined and unjust actions condemned in Olo versus Kisumu County Assembly Service Board and another, rendering the resulting decisions absolute nullities. Submitting on public participation and institutional incapacity, it was His Excellency Gachagua's case that both houses entirely failed the threshold. He referred to the decisions in Mohammed and 6 others versus County Assembly of Wajir and other cases which we have stated. To reinstate that engagement must be substantive, one that allows reasonable time and utilizes satisfactory mechanisms. In addition to the foregoing, His Excellency Gachagua, while drawing support from the decision Independent Electoral and Boundaries Commission vs. Attorney General 2025, discredited the involvement of the IEBC, arguing that constitutional functions requiring commission approval could not be lawfully discharged by the Secretariat without a properly constituted commission. In their rejoinder submissions, the legal team also spoke to procedural illegality in plenary investigation. It was His Excellency Gachagua's submission that the Senate lacked a lawful resolution to appoint a plenary investigation. They submitted that the word may in Article 145, Sub-Article 3B, regarding the appointment of a special committee is a mandatory obligation, relying on a set of authorities including Sony Holdings versus Registrar of Trademarks and another. They submitted that courts routinely interpret may as mandatory to effect legislative intent, to effectuate legislative intent. Tracing the constitutional drafting history from the Guy and Bomas drafts to the Wako and Harmonous drafts, it was their case that it proved the framers consistently intended for a special committee to investigate charges prior to any plenary vote. In conclusion, His Excellency Gachagua drew inspiration from the Filipino Supreme Court in Sara Duterte versus House of Representatives. We have given citation to reiterate that impeachment processes remain strictly subject to the Bill of Rights to check grave abuses of discretion. Consequently, they urge the court to utilize its discretion as established in Imanyara and 2 others versus Attorney General to award damages for the constitutional violations to vindicate His Excellency Gachagua's right and deter future legislative infringements.
I will proceed from the second petitioner's case, that is Thomas Kimoto Maingi. Thomas Kimoto Maingi, the second petitioner in the consolidated petitions, filed a petition dated 25th September 2024 before the High Court at Kerugoya. The petitioner described himself as a former member of the National Intelligence Service, NIS, and contended that his constitutional rights had been violated by statements allegedly made by His Excellency Gachagua on 26th of June 2024 concerning the conduct of NIS during the Finance Bill 2024 protests. He averred that, having served in the NIS for over 20 years before retiring in May 2022, he was publicly associated with the intelligence service within his community, and that the remarks by His Excellency Gachagua portrayed NIS officers as incompetent and responsible for the unrest and loss of life witnessed during the protest. He asserted that the remarks exposed him to ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachagua appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and or speech made on the 26th of June 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submissions. The third petitioner's case. Honorable Njeri Maina, the third petitioner in the consolidated petitions, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion as and in public interest, her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachagua. She contended that the public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and constitutional owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution, and challenged the constitutionality of Standing Order number 64, 2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings in plenary instead of through a special committee under Article 145, Subarticle 3B of the Constitution, urging that investigation of impeachment charges could only lawfully be undertaken by a select committee of the Senate. In addition, she challenged the legality of the National Assembly as constituted, contending that it failed to comply with the constitutional two-thirds gender principle under Articles 27, 81B, 102, 161 of the Constitution, and was therefore incapable of lawful entertaining an impeachment motion. As such, Honorable Maina sought for the following reliefs. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024, as ordered by this Honorable Court regarding the special motion, were in disregard of the Court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process as against the first interested party undertaken by the first and the second respondents in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional and therefore void. D, a declaration that the appointment of a select committee by the Senate under Article 145(3)(b) of the Constitution is not discretionary in the impeachment of a president or deputy president in light of Article 259 of the Constitution. A declaration that any proceedings in regard to impeachment of the first interested party taken by the second and fourth petitioner respondents outside the select committee of Senate under Article 145 sub-article 3B of the Constitution are unconstitutional and void. F, a declaration that the first respondent is not legally constituted in light of the mandatory provisions of Article 27, 81B, 102, 61 of the Constitution on the two-thirds gender requirement. G, a declaration that the first respondent as currently constituted cannot entertain and deliberate the special motion for the removal of the first stated party by respondents. H, cost of the suit, and I, any other order or orders that this court may deem just. The third petitioner's submissions. Honorable Maina supplemented her positions by filing written submissions dated 9th of January 2026, and which she further orally highlighted in court. She identified the following issues for determination. 1, whether the public participation exercise conducted by the National Assembly on the 4th of October 2024 met the constitutional threshold under Article 118 of the Constitution. B, whether the yes-no templates deployed by the National Assembly violated constitutional requirements for meaningful public participation. 3, whether the Senate violated Article 118 by not conducting public participation at the Senate stage. 4, whether the Senate violated Article 145(3)(b) by failing to appoint a special committee of 11 members. 5, whether Standing Order 64(2) prescribing a 12-day impeachment timeline is constitutional. 6, whether the impeachment process violated Article 50 on fair hearing protections. And 7, whether the impeachment proceedings were conducted by impartial officers as required by Article 50, sub-article 1 of the Constitution. Honorable Maina submitted that on the 3rd of October 2024. Honorable Justice Mongo, a judge of the High Court sitting at Karibuya, ordered inter alia that public participation be undertaken at the constituency levels so as to accord the public an opportunity to engage and offer their representations. That these orders were duly served and were never appealed, stayed, varied or reviewed, and as such, they remain binding on the respondents absolutely. Speaking to the obligation to obey court orders, Honorable Maina submitted that such obedience is foundational to the rule of law as was held in Law Society of Kenya and 3 others versus Inspector General of Police, and 4 others reported in 2024 KEHC, KLR. She submitted that this obligation extended even to cases where the person affected by an order believes it to be irregular or void, as was held in Refrigeration and Kitchen Utensils Limited versus Gulab Chand, Popatlal Shah, and others, the civil application number Nairobi 1339 of 1990. She further submitted that proper compliance required reasonable notice and not the same day or the next day notice. Physical accessibility at constituency level with open, identifiable venues in each of the 290 constituencies, facilitation of engagement, including civic sensitization, information, language diversity, disability access, and hearings as the primary mode, including oral and interactive engagement. Learned Council further submitted that the orders were not obeyed and only 200,000 participants countrywide who made up to 0.4% of the Kenyan population turned up for the exercise. Council decried the one-day notice published on a Saturday, whose contents were vague as they referred to constituency offices without addresses and times. She also pointed out that no hearings were ever organized, no facilitation was provided, and that CDF offices were closed and the MPs absent. Honorable Maina submitted that she became aware of the purported exercise only past midday and that none of her counterparts within the Kirinyaga County were aware of the exercise. She further submitted that even the citizens who visited the constituency venues found them locked and no officials or staff were in sight. It was submitted that the National Assembly faced a binary choice of obeying the Constitution through the court order or preserve Standing Order 64-2, of which provided for 7 days deadline. They chose the latter, which Honorable Maina describes as contempt dressed as obedience. That a legislative outcome obtained in defiance of a binding court order cannot stand in a constitutional democracy governed by the rule of law as discussed by Lord Denning in McFoy versus United States Company Limited, United Africa Company Limited, reported in 1961, 3 All England Reports 1169, where the learned judge held that, I quote, if an act is void, then it is in law anality. You cannot put something on it and expect it to stay there. It will collapse, end of quote. Honorable Maina also took issue with the yes and no template as constitutional fraud, as the National Assembly deployed a standardized template reducing 7 complex constitutional allegations into binary tick box questions. That citizens were asked whether they supported impeachment on each ground without being supplied with evidentiary material, explanatory memoranda, and His Excellency Gachagua's response, relying on the Supreme Court and British American Tobacco BAT versus Cabinet Secretary for Health 2019, which we'll hereinafter be referring to as the BAT case. She articulated attributes of meaningful participation to include clarity of the subject matter for the public to understand structures, processes that are clear and simple, opportunity for balanced influence from public, commitment to the process such that views can influence outcomes, and inclusive and effective representation. She also listed integrity and transparency of the process and capacity to engage on the part of public, including sensitization of the subject matter. Honorable Maina admitted that the digital-only, English-only mechanism systematically excluded rural residents, the elderly, persons with disabilities, the non-English speakers, and the non-English speakers. She stated that there were no physical venues for explaining the template or receiving oral views, that were only in 10, that there were only 10 pictures of people attached as evidence of attendance for the 5th October exercise, and that they were contained and that they were conflated responses from 4th and 5th October without distinction, obscuring the impact of the court's orders. She identified that the template was not a procedural imperfection, but an endorsement mechanism designed to manufacture numerical support for a predetermined outcome and is therefore constitutionally void. It was her further submission that Article 118 imposes an independent obligation on each House of Parliament to facilitate public participation in its own business, that the Senate is not a subordinate appendage of the National Assembly, as was held in Speaker of Senate versus Attorney General, reported in 2013, where she stated that the Senate's role in impeachment is determinative under Article 145(7), as it performs a quasi-judicial function of the highest constitutional order. She held the position that the Senate could not constitutionally rely on the National Assembly's defective process, particularly where that process was conducted in defiance of court orders. That the Senate was aware of these defects as they were documented, litigated, and judicially acknowledged. Counsel submitted further that in Mwangaza versus Speaker of the Senate 2025, reported in 2025 Kinyalo report, this court held that Senate must satisfy itself that public participation was adequate and satisfaction requires inquiry, assessment, and independent judgment, but the Senate undertook none. That the Senate conducted no public participation whatsoever, as no notices were issued, no invitations were extended, no hearings were conducted, and no submissions were received, and that this is not a case of inadequate participation, but a case of none at all. It was also her submission that Article 145, Subarticle 3B of the Constitution provides that the Senate may appoint a special committee comprising 11 members of its members to investigate the matter. On that, she submitted that the word may was a grant of power, not a license to bypass the Constitution, and that once the Senate had elected to proceed under Article 145, it must proceed within the architecture prescribed, which includes a special committee. She further stated that under Article 145, Subarticle 6, it provides that the Senate jurisdiction to vote is triggered only if a special committee reports that allegations have been substantiated, and absent a committee report, the gateway to plenary determination was not opened. She also stated that the constitutional function of the special committee was structured investigation, not political debate, receiving, interrogating, and testing evidence, producing a reasoned report, and insulating investigation from the volatility of plenary politics. That Article 145, Subarticle 5 of the Constitution, guaranteed the Deputy President the right to appear and be represented before the special committee, and by bypassing the committee, the Senate extinguished an entire constitutional hearing stage guaranteed to the Deputy President, thus violating the non-derogable right to a fair hearing. Learned Counsel submitted that standing orders confirmed this distinction as Standing Order 79 on the Deputy President impeachment provided for a special committee, but no alternative. That Standing Order 80 of the Governor's impeachment procedure, impeachment expressly provides two alternatives, that is, a special committee or a plenary investigation. It was then posited that where the drafters intended to permit plenary investigation, they could have said so, and that the omission of the Deputy President must be respected. Learned Counsel drew parallels to Section 33(3)B of the County Governments Act, which provides that the Senate may appoint a special committee in governor impeachments, and that the courts, including Wambora, have held that this confers discretion and the Senate has lawfully proceeded in plenary. That those decisions underscore the opposite point, that where law expressly provides alternatives, discretion exists, but where the Constitution provides only one investigative pathway, the discretion does not extend to inventing another. She submitted that by proceeding to plenary determination without appointing a special committee, the Senate acted without jurisdiction, bypassed a constitutionally mandated investigative stage, and extinguished a guaranteed hearing right. She also submitted that Senate had collapsed constitutionally distinct phases into a single political exercise, and the impeachment proceedings were therefore unconstitutional, null, and void ab initio. It was a further submission that Standing Order 64-2 lay at the heart of the constitutional infirmity, as it imposed unreasonable timelines that rendered compliance with the Constitution impossible. Council invoked Article 2(4) of the Constitution, which provides that any law that is inconsistent with the Constitution is void to the extent of the inconsistency. She placed reliance on Orange Democratic Movement Party versus Speaker of the National Assembly, reported in 2024, where this court affirmed that standing orders cannot override the Constitution nor substitute the constitutional requirements of public participation as expounded by the courts. In that light, Parliament's invocation of good faith was faulted, it being argued that Standing Order 64-2 structurally precluded constitutional compliance. She submitted that where standing order made adherence to constitutional obligations impossible, such a standing order is itself unconstitutional. It was further submitted that Standing Order 64-2 embodied a deliberate parliamentary choice to prioritize political expediency over constitutional safeguards. By prescribing rigid timelines, it ensured that once an impeachment motion gained initial traction, the process would be driven to conclusion before public sentiment could evolve, before courts could intervene meaningfully, or before the affected office holder could mount an effective defense. Council argued that this was precisely what the Constitution sought to prevent, since impeachment is not a mere vote of no confidence, but a quasi-judicial constitutional process carrying grave consequences. On that basis, it was argued that this court should declare Standing Order 64-2 unconstitutional, null and void, to the extent that it prescribed timelines incompatible with constitutional requirements, and that any impeachment conducted under its terms is tainted with illegality from inception. On the question of whether His Excellency Gachagua was accorded a fair hearing, Honorable Maina submitted that he was hospitalized with chest pains on the eve of the Senate proceedings. Despite medical evidence of incapacity, the Senate proceeded with a hearing and voted, thereby violating the most basic tenet of the fair hearing rule, audi alteram partem, meaning no person shall be condemned unheard. Council further argued that the 12 days between service of the motion and the National Assembly vote were constitutionally inadequate, given that Article 50, Subarticle 2B, guaranteed the right to have sufficient time and facilities to prepare defense. His Excellency Gachagua, it was emphasized, faced 11 complex constitutional allegations, including gross violation of the Constitution, abuse of office, and corruption, for which 12 days was structurally insufficient. As the Supreme Court affirmed in Sonko case, which we referred above, impeachment proceedings attract the protections of Article 50, and where a fair hearing is denied, the process collapses. On the issue of bias and predetermination, Learned Counsel submitted that both Speakers of Parliament, as presiding officers over the impeachment motion, were constitutionally required to maintain impartiality, but acted contrary. It was argued that they assumed the role of initiators and proponents of the impeachment, thereby transforming into advocates for the motion rather than neutral arbiters. In particular, Speaker Moses Wetangula of the National Assembly was said to have participated in public statements endorsing the impeachment before presiding over the proceedings. Council emphasized that the test for bias is objective, where a reasonable, fair-minded observer would conclude that there exists a real possibility of bias, and submitted that the Speaker's public statements and advocacy for impeachment satisfied this threshold. Where the presiding officer is biased, she argued, the proceedings are fundamentally unfair, and the failure of the speakers to rescue themselves irredeemably tainted the process. For the above reasons, Honorable Maina urged the court to grant the relief sought in her petition. Next is the 4th to 8th petitioners' cases. The 4th to 8th petitioners in the consolidated petitions, that is Honorable David Munyi Madenge, Peter Gechobi Kamoto, Grace Modoni Mwangi, Clement Muchiri Muriuki, and Edwin Munene Kariuki jointly filed a petition dated 18th of October 2024 before the High Court of Kenya at Kerugoya. They describe themselves as residents and leaders drawn from various constituencies within Kirinyaga County, and stated that they instituted the petition both in their personal capacities on behalf of their residents of their respective constituencies and in the wider public interest. The petitioners herein challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua, together with the subsequent nomination and approval process relating to Honorable Kindiki, relating to His Excellency Kindiki as Deputy President nominee. They contended that the public participation process conducted by the National Assembly on the 4th and 5th October was illusory, inaccessible, and unconstitutional. In particular, they pointed to the issuance of short and ineffective notices, lack of sensitization, inaccessible venues, absence of parliamentary officials at designated constituency sites, closure of the Kirinyaga Central CDF Hall, and the overall failure by both National Assembly and the Senate to facilitate meaningful participation as required under Articles 10 and 118 of the Constitution. The petitioners further asserted that Senate unlawfully conducted impeachment proceedings in plenary instead of through a special committee under Article 145(3)(b) of the Constitution, and that the rash timelines imposed under Standing Order 64(2) of the National Assembly standing orders were unconstitutional as they curtailed effective public participation and the hearing and the fair hearing rights. They also alleged that the Senate violated His Excellency Gachagua's constitutional allegations. They also alleged that the Senate violated His Excellency Gachagua's non-derogable rights under Article 25(c) and 50 of the Constitution by refusing to adjourn proceedings on the 17th of October 2024, despite his hospitalization and medical emergency, thereby denying him an adequate opportunity to be heard. In addition, the petitioners challenged the legality of the nomination and approval process of His Excellency Kindiki as Deputy President nominee, contending that the process contravenes Sections 3 and 6 of the Public Appointments Parliamentary Approval Act, Chapter 7 of the Laws of Kenya, for want of adequate notice and public participation. The petitioners then sought the following prayers. A declaration that the appointment of Professor Kithure Kindiki, the second interested party herein, as Deputy President of the Republic of Kenya is invalid, null and void. B, a declaration that the National Assembly as a distinct organ is required to undertake its own distinct, proper, effective, and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to the impeachment of a president or a deputy president. C, a declaration that the Senate as a distinct organ was required to undertake on its own distinct, proper, effective, and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to a resolution from the National Assembly to impeach a president or a deputy president. D, a declaration that the public participation as scheduled by the first and the second respondent on 4th of October regarding the special motion was not a proper and effective and meaningful public participation as envisaged in Articles 10 and 18 of the Constitution. E, a declaration that the extended public participation scheduled by the first and second respondents on 5th October 2024 was in disregard of the court orders issued by the High Court sitting at Kerugoya in constitutional petition number E014 of 2024, Honorable Jane Jerry Maina versus the National Assembly and 4 others, and was not a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. F, a declaration that the impeachment process as against the first interested party was undertaken by the first and second respondents in view of the impugned, improper, ineffective, and meaningful public participation held on the 4th and 5th October was unconstitutional and therefore void. G, a declaration that the failure by the third and the fourth respondents to undertake any public participation at all in regard to the impeachment proceedings in the Senate as against the first interested party renders the whole Senate impeachment process unlawful and void. H, an order of certiorari to bring up into this honorable court and quash the decision and or the resolution by the first and the third respondents met on the 8th of October 2024 and 17th of October 2024, respectively, resolving to remove the first interested party as deputy president of Kenya by impeachment. I, a declaration that there exists no vacancy in the office of the deputy president, allowing the fifth respondent to nominate anyone to fill such vacancy, and that any such nomination is unlawful and void. J, any other order or orders that this court shall deem just and expedient in the circumstances. K, cost of the suit. Next is the 4th to 8th petitioners' submissions. In their submissions led by counsel, Mr. Evans Ogada, together with Mr. George Sakimpa, the 4th to 8th petitioners identify the following issues for court's determination. A, whether the impeachment process complied with Articles 10, 118, 145, and 150 of the Constitution, whether the public participation conducted by the National Assembly and the Senate met the constitutional threshold of being meaningful, adequate, effective, and lawful. C, whether a standing order 64-2 of the National Assembly is unconstitutional for imposing rigid timelines that undermine constitutional safeguards. And D, whether Article 145 and applicable standing orders require that investigation into impeachment charges be conducted exclusively by a special committee of the Senate, not by the Senate sitting in plenary. They submitted that Article 10 binds all state organs, including Parliament, to the national values such as democracy, public participation, the rule of law, accountability, and good governance. That the impeachment process was conducted with severe haste and limited deliberation, undermining transparency, accountability, and public participation. They relied on the Supreme Court decision in Speak of the Senate versus AG and another reported in 2013, where it was held that Parliament was not exempt from constitutional discipline. They submitted further that Article 118 required Parliament to conduct business openly and facilitate public participation, and that this was not a formality, but a substantive constitutional obligation. They contended that the National Assembly gave the public less than 48 hours to consider complex, voluminous impeachment charges, which is a manifestly inadequate time frame, that no explanatory notes or responses from the deputy president were provided, and that in some counties, like Kirinyaga, designated venues were inaccessible. They further asserted that the Senate conducted no independent public participation at all, as it relied on the National Assembly's deficient exercise, which cannot cure the constitutional breach. And they relied on authorities in Law Society of Kenya versus National Assembly of Kenya, 3 others, reported in 2025 KLR, National Assembly and another versus Okoit and 55 others, Civil Appeal number E003 of 2023, consolidated with others. This is the decision of the Court of Appeal. They also relied on the decision of Doctors for Life and and the decision in Legal Advice Center, and 2 others versus County Government of Mombasa. On the unconstitutionality of the National Assembly Standing Order 64-2, Learned Counsel argued that the provision imposes rigid and unreasonable timeline that make meaningful public participation impossible, and that while Article 124 empowered Parliament to make standing orders, such orders are subordinate to the Constitution and cannot defeat constitutional rights, and Article 2.4 voids any law inconsistent with the Constitution. The petitioners urge the court to declare Standing Order number 64-2 unconstitutional. As the matter in which the Senate proceedings were to be undertaken, Council submitted that Article 145.3 provided that the Senate must appoint a special committee to investigate impeachment charges, and that the use of the conjunctive and between sub-articles A and B makes the special committee process constitutionally inseparable from the investigative phase. That Articles 145, Sub-Article 4, Sub-Article 5, and Sub-Article 6 refer exclusively to the special committee, and that there is no mention of plenary investigation or under expresso inius est exclusio alterius, that excluded all other modes of investigation. The petitioners submitted further that the special committee ensued suppression of investigations and adjudicative functions, preventing bias and predetermination, and the Senate's decision to bypass the special committee and proceed in plenary fused investigation, hearing, and the judgment into a single political process, violating the hierarchical and sequential structure of Article 145. Learned Counsel placed reliance on Martin Nyaga, Wambora, and 3 others was the Speaker of the Senate. This is the Court of Appeal decision, where the Court of Appeal held that the removal of a governor, which mirrors Article 145, is hierarchical and sequential in nature. Counsel argued that the Deputy President was denied a constitutionally prescribed procedural safeguard available to state officers facing removal, thereby violating Article 27 on equality and non-discrimination. They further submitted that Article 50, Sub-Article 1 guarantees the right to a fair hearing, which is expressly protected as non-derogable under Article 25C. Proceeding with impeachment proceedings while the Deputy President was hospitalized and rejecting a reasonable request for adjournment amounted to a gross violation of natural justice. Counsel emphasized that fairness was the unassailable foundation of any removal process. In support, they cited Gachagua versus Speaker, National Assembly, and 3 others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Counsel concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency, and urged this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and that the impeachment process violated Article 10, 118, 145, and 150. A declaration that Standing Order 64-2 is unconstitutional, a declaration that the Senate unlawfully bypassed the special committee, and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria Mtaani na Shedrack Wamboi, a public benefit organization, filed the petition dated 18th of October 2024, together with a supporting affidavit sworn by Dorcas Mwai, an advocate of the High Court of Kenya, and a director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protecting constitutional rights, and promoting the rule of law, constitutionalism, accountability, and good governance. The petition challenged the constitutional and the legal validity of the impeachment proceedings, leading to the removal of His Excellency Gachagua from office as Deputy President, and further questioned the legality of the intended nomination and approval of His Excellency Kindiki as his replacement. It contended that the Senate proceedings conducted on the 17th of October 2024 violated His Excellency Gachagua's constitutional rights under Article 25C, 47, 50, and 45, Sub-Article 5 of the Constitution. That the Senate unreasonably declined to adjourn the impeachment proceedings despite being informed that His Excellency Gachagua had fallen ill and had been admitted at Karen Hospital, thereby denying him an opportunity to personally defend himself against the impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fair hearing, procedural fairness, and natural justice by proceeding with the impeachment in the absence of His Excellency Gachagua, while allowing the proceedings to continue on the basis of strict constitutional timelines. It asserted that although the Constitution contemplated an expeditious impeachment process, the constitutional timelines could not override His Excellency Gachagua's non-derogable right to a fair hearing and adequate opportunity to defend himself. Sheria Mtaani na Shedrack Wamboi further complained that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice and constitutional safeguards. Additionally, the ninth petitioner challenged the legality of the subsequent process initiated by His Excellency the President to nominate His Excellency Kindiki as Deputy President under Article 149 of the Constitution. It was contended that the nomination violated Articles 82, 88, and 137 of the Constitution because IIBC was allegedly not properly constituted and therefore incapable of lawful verifying the constitutional qualifications of any nominee to the office of the Deputy President. Sheria Mtaani na Shedrack Wamboi also argued that His Excellency Kindiki's nomination contravened Article 137 of the Constitution on the basis that he remained a serving Cabinet Secretary for Interior and National Administration at the time of his nomination. For these reasons, the organization sought the following prayers. A declaration be and is hereby issued that the rights and fundamental freedoms of the interested party herein, to which his rights and fundamental freedoms under Articles 25, 50, 27, 47, 145 were grossly violated by the third respondent on the 17th of October 2024 for declining to grant him an adjournment on the Senate sitting deliberating on his removal from office by way of impeachment. B, a declaration does hereby issue that the decision by the third respondent to have the interested party removed from office by way of impeachment to the extent that it was done in gross violation of Articles 25, C, 50, 27, 47, and 145.5 of the Constitution was unconstitutional to the extent of its unconstitutionality, and null and void ab initio. C, a declaration that any subsequent replacement of the interested party